So design responsibility is a very important sort of topic to any professional involved in construction and development, and has become more important in terms of New South Wales with the Design and Building Practitioners Act, which has changed a good few of the rules and has introduced a new talking point around responsibility. So if you start off with the topic, the first thing you've got to realise is that design doesn't have a very certain meaning. An architect who did the original sketch for the Sydney Harbour Bridge could say, well, I did the design because I gave the concept. Alternatively, the person who designed the rivets to hold the steel members together could say, well, look, I did the most important part of the design because that's what holds the bridge together. And within that varying expanse, you've got to be clear as a designer as to what your brief is. Is your brief to shift the bridge to a better spot, or is your brief simply to design the beams that connect the pylons to the pylons? And you'll see that where you have a dispute over design responsibility, it's often over the lack of definition of the limits of the design responsibility of the particular professional. The other aspect to realise is there's a few sources of design responsibility. One is in contract. If I contract to design a tower to be suitable for use in a particular location and it's left unqualified, then I've probably got a pretty strict liability to design that tower to withstand any sort of weather, any sort of earthquake at that location, simply because I said, I will design you a tower for that location. That's my contract, that's my fee, and that's what I've got to produce. Now that's to be contrasted with a sort of common law duty where one says, as normal professionals do, look, I'll use reasonable care to get you the result that I think you deserve. That is, I don't guarantee that it will necessarily perform, but I will use reasonable care to design a structure that will perform. So that's a less responsible position. The situation is that you then have another source these days, increasingly common, of statute liability, which says that if you design a farm gate, it must be designed in accordance with a certain code, and that's a regulation of the local shire. So that means, therefore, that you might have a strict liability to comply to that particular code. And again, as we'll see, the Design and Building Practitioners Act in New South Wales has imposed some very onerous obligations, imposing obligations to take care on building and design practitioners. So those three responsibilities matter as to what standard you have to design for. Is it the more absolute standard of a contract, or is it the more gentle standard of the common law negligence? Or alternatively, is it perhaps a very strict standard under a piece of legislation? Most of this is a discussion of negligence, in the fact that there's negligence is the failure of a person to discharge a duty of care. And when one's talking about that sort of duty, one has 3 to 4 elements in it. Firstly, you've got to establish that you owe a duty in the common law. So you have to establish, well, as a car driver, I owe a duty to pedestrians that cross the road. As a doctor, I owe a duty of care to my client not to chop off the wrong legs. But I don't owe a duty as a doctor to perhaps protect the granddaughter of the patient from nervous shock. Perhaps that's too remote, that's too far away from the doctor's sense of responsibility. So the question is whether you owe a duty is a very interesting question at law, and the law has been slow over the years to expand that duty because it doesn't want to upset the usual position in society that everyone looks after themselves, and it's only those who are in special sort of proximity to others that are bound to take particular care. If I set up a fish shop in Chatswood, I don't have to use a duty of care. I have to observe that duty of care as I travel the road. So the law looks at categories of people and imposes on them particular duties. The next aspect that's important in negligence is the proof of damage, the proof of the breach of that duty. That is, I owe a duty to be careful. Did I brief it? Or did I actually go through a careful process of checking that it was appropriate and something unexpected came along to cause some problems? If it was unexpected and outside the duty of care, then I don't have to worry about it. And again, you've got to show a causation with damage. You've got to show that from that breach of that duty of care, damage flowed. And until there's damage, there's no real cause of action. There's a reflection in that as to how long the liability exists. And in contract, it'll exist broadly for 6 years, but increasingly by a special extension to a term of 10 years. Negligence, in theory, is running on the same issue, particularly if it's a building contract, but negligence has the interesting aspect that the ability to sue somebody expires 6 years after the damage was caused. So theoretically, if somebody carries out a duty today and designs something that is unsafe and damage doesn't occur for 20 years, technically he might still be liable to somebody to sue him within 26 years. So it has that long tail aspect that isn't usually found in the contractual duty. So if we start with the slides, we introduced this Design and Building Practitioners Act. It's come in, it's a very big expansion of the duty for designers, builders and certifiers. And the situation is it was helpfully backdated 10 years by Parliament, which is a very radical manoeuvre, so that if you were careless 7 years ago, you would be under this act, if you come within its terms, liable for that result. So it's a substantial risk to both the builders, that is people doing the work, and also those who design the work. So it's important that you're aware of it and you're conscious of the responsibilities. So the first case I'd like to start off with is an example of the common law as it was back in, Gough Whitlam's day. And this is a case in 1963 of Bolly's case. An architect effectively designed a stage which collapsed, and the situation is somebody was injured and they sued him, and it was held that he owed a duty of care to the owner and the public to design that stage properly. So the circumstance is that was a pretty significant case back then, and that demonstrates how this responsibility for your neighbours has grown over the years. What was a significant case then is accepted as fairly basic and run-of-the-mill now. So in Bolly's case, what was important was that he held himself out as a specialist, and he took on the responsibility of designing the stage, and those are the factors that caused the court to have a liability imposed on him for the damage that was caused to the owner and to the public. So the negligence arose in 1932, which in legal terms is not too long ago, and there was a case where a lady consumed a bottle of soda water with a snail in it. When she realised there was a snail in it, she was quite obviously disturbed. But she didn't have a contract with anyone worth suing. Probably the shopkeeper wasn't worth powder and shot. And the circumstance is then she said, well, the manufacturer owed me a duty of care to provide me with safe food. And it's that case that ran forward, and it's the foundation of a lot of negligence claims that have developed since then. And the principle was that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. And that's Lord Atkin's sort of seminal sort of statement of the principle. So the situation is the manufacturer owed a duty of care to the consumer, even though they'd never met, they had no direct interaction, and the significance of it is that it effectively establishes a duty to look after your neighbours, to look after those that are going to be closely affected by your actions, and make sure that you take the care to avoid that. Looking at construction, you've got structural failures, design or execution, errors in plans or specification, faulty advice, supervision or inspection. And to prove negligence, you must show there's a duty owed. So you might not have a duty to for the quality of a work to another subcontractor who's working on another area of the site, but you might have a duty to your head contractor or to the principal who are in a legally more proximate and close relationship with you. Having established that somebody owed you a duty, you've then got to say what was that duty and how was it breached. So usually it's stated as a duty to take reasonable care that the injury wouldn't happen. So you've got to show that he didn't take reasonable care, because he took reasonable care and it still happened. He's not liable in the standard negligence. You've then got to say that the damage was caused by his breach. So if he failed to secure some logs and the logs fell on you, then you could say, well, that's a clear causation between the breach and the damage. So in order to protect yourself, if you're a designer or if you're a participant on any construction sort of environment, is to make sure that you've recorded what you've done, to make sure that you've carried it out with care, and that you have got sort of evidence to back it up. So then comes the situation of the law was slow to advance in this area, and while it was happy to deal with the more physical injury of Donoghue in the original case, it had some problems in picking up completely commercial or economic loss. And the situation there is that you could cause economic loss to a lot of people by the actions you take. If you cancel a contract, which you're entitled to cancel, that'll cause some economic loss to a neighbour, but you don't have a duty of care in that respect. You might have a situation where you can corner the market in a particular good, and that might cause a lot of economic pain to people. Again, you don't have to account for that. Again, you might turn up late for some appointment, or you might do something, but if it's not a aspect where you owe a duty not to do it, then the liability doesn't attach under these principles. So the key concern for the courts was the risk of unlimited claims. The courts were worried about opening the floodgates. If they said that every person owed a duty to a wide range of people, then it would be catastrophic for the usual commercial and economic relationships. So if you had to take care to avoid a huge amount of damage to a huge amount of people, then the activity itself was a problem. You'll see an example of that in the not too distant future. People that were conducting events were getting increasingly concerned that they were exposed to a large amount of claims from a large amount of people who might be turning up at their event and perhaps finding that the venue wasn't suitable and were suing them for economic loss. And that resulted in them having to get insurance, and the insurance was very expensive, and hence there's been a lot of criticism in recent times as to trying to limit the liability in order that people could still enjoy the events which otherwise weren't commercial to conduct. The court was particularly interested in a number of considerations which they used to argue their way through to deciding who was liable and who wasn't. And it's best that you have a working understanding of that. One is the relationship or the proximity, and that's a proximity both in sort of time. If you're driving along the same road as a pedestrian, then perhaps you owe him a duty of care. Also, proximity of association. If you're a veterinarian and you're looking after someone's dog, well, you've got a proximity to him that your actions are going to directly affect that dog. So therefore, you should be alert to your duty. And the vulnerability of the claimant. Obviously, if you take on to care for somebody who can't fully defend themselves, then of course there's more likelihood that you'll attract a duty to be careful in your interaction. And the defendant's control over the risk. So if you had a situation where the defendant was partially involved, he was able to judge his risk and take his own judgment on it, then the situation is there's less concern over finding a duty. So those are important sort of characteristics when we come to look at some of these cases. The other aspect is that what is economic loss, and it's sort of financial loss rather than physical injury or property damage. The law is fairly responsible if you get a physical injury to finding a remedy for you, but if you just lost money on the stock market, then they're not really interested in finding a villain. And again, property damage is a little bit more basic and classic. If somebody chops down your tree, well then, you know, perhaps they should be penalised. Alternatively, financial loss is seen to be a little bit more remote and a little bit less direct, and therefore the law had a struggle to find that. But these days, particularly under the Design and Building Practitioners Act, that threshold is being crossed, and that's why one's liability for design and building these days has significantly been expanded. So two types of pure economic loss. One is where it directly follows physical damage, and again, repair costs. If somebody damaged your good, is fairly direct, and that attracted less scrutiny. But if there was just lost profits, that is, you had a motor car accident and you said, well, you know, I would have been going to the races and I would have put money on tough far lap, and I didn't get the races, so therefore you should pay me what I would have won on far lap. And the courts are saying, well, that's too remote. That's not what the sort of thing that we need to deal with. So the aspect then is we have to look at some of the cases that the courts have worried through to get a bit of an approach to this. So the situation is that in Hedley, Byrne and Heller, somebody said this fellow is, you know, solid as a Bank of England. And of course, he went into liquidation and somebody lost a lot of money by dealing with him. And there, in a big advance to law, the House of Lords said, well, where there's a special relationship, where there's the advisor who's giving the advice, assumes a responsibility, he holds himself out, he was a merchant banker of some sort, and there's clear reliance on that, then the duty of care can arise. And they summarised as saying that if someone is possessed of a special skill, undertakes, quite irrespective of contract, to apply that skill for the assistance of another person who relies upon it, a duty of care will arise. So that was a significant step forward to where pure economic loss was going to be recognised by the law. So you've got that sort of aspect. The examples in construction: certification of compliance, expert reports for investigation, design advice. So somebody there is holding himself out to be competent and specially qualified, and there's clear reliance by a claimant, and the situation is usually foreseeable. So you can see that these cases consider concepts that are going to be relevant to construction. And the situation is, though, the law is wavered in the development, and in Spartan steel, contractors negligently damaged a cable, cutting electricity to Spartan's factory. They claim for the physical repair and the future profit loss. And the court allowed recovery for the physical damage, but didn't like the claim for pure economic loss, like future profits. So it clarified that there was some limits on what you could look for. The loss directly limited the property damage, was likely to be sort of recoverable, but indirect financial losses, not so. So it just demonstrates the courts are cautious. It also demonstrates that plaintiffs do like exploring those extents. So if you tell someone that the design that you've got is the best in the world and it'll really work well, and in fact it isn't, then the circumstance is that you'll certainly find a plaintiff available to help you understand the facts. Now, the other case, looking at the extent of the liability that one could entail in some of these aspects, was demonstrated by this case of Pierre and Apand, which is two potato farmers, and one imported a potato that was contaminated with a disease, and the other farmer said, well, it's contaminated my farm and my potatoes are not good at all. So the question is, here courts tried to, I think, respond to the second farmer's problem, but wanted to do so in a way and with reasons that restrained the extent of the consequences on a reasonably innocent offender. So the defendant only breaches a duty of care, it said, when it both knows or ought to know of a risk of harm and does or fails to do that act and has reasonable means available to it of avoiding that harm. So it introduced a situation of sort of reasonableness. If it was impossible to avoid, well then bad luck. But if it was easy to avoid and they knew that there was a risk of harm, then the courts were going to move that way. And the other question asked is, how vulnerable was the plaintiff to incurring loss? So they were worried about protecting those in the community that couldn't protect themselves. They were worried about vulnerable people being oppressed by other people taking risks and failing to take care, and there being no remedy. So that was seen to be in 1999 a significant expansion of the circumstances in which negligence would be seen to create an issue and a controlled situation for recovery. So again, we see, is the harm foreseeable? Was the claimant vulnerable? Did the defendant control the risk? And was there sufficient closeness between those aspects? So then we want to look a little bit at the Designers and Builders Practitioners Act to clarify the extended liability for design and construction professionals. And the Act is not only an extension of your duty of care, it's also the imposition of a whole series of certifications and responsibilities, investigations and penalties that are associated with bad building or bad design of building. So it's a pretty ambitious act, and it's meant to, probably in its aims, to sort of clean up the industry, to make sure that the industry responded better to the loss that was being caused to the community. The matters that tended to accelerate its imposition were the strata units, high rise, that were showing cracks and poor workmanship and causing a great lot of concern to the community, but also loss to the people who had bought the property, not knowing of its problems. So, just running over its key things, it's a duty to exercise reasonable care to avoid economic loss due to building defects. So what it's saying is that we won't have this trepidation about economic loss anymore, and that if there's building defects, there'll be a problem. And it's non-delegatable, can't pass the responsibilities on to the subcontractors and forget it, it's responsible for it. It can claim from subcontractors and consultants and other people, but it doesn't get off its initial responsibility. And it applies individually to designers, supervisors, builders and consultants. Situation there is that, you know, if as a consultant you're designing some part of a construction that's covered by the Act, then you'll be personally reliable as well as the company that you might be working for. So it's a very important and significant liability, and that's why you've got to be careful about the design you do, and also, in a second stage back, careful about the amount of property that you hold in a situation which can be attacked. So practical tips is you ensure compliance, you do reviews and peer reviews in order to cut matters off, and you have your regular training. After the Act, there's a clear statutory obligation, higher standard of accountability, and increased exposure for personal liability. So again, it's calling on the designer and the builder to improve their game. Some of the cases that around this time explored the possibility that a builder had a duty of care to future owners of a property. That is, that if the builder's building a building, he's building it for a developer. He might have a duty of care to the developer to get it built properly. But if the developer sells it on and three owners later, the present owner notices a crack and there's water coming in the windows, then can he sue the builder? You know, the reality of that was that probably a developer had paid the builder and sold the property and disappeared into the ether, but the builder was still around to be sued. So the issue was, can he be saddled with the duty of care to the whole of the purchasers that booked for it? The circumstances, there's cases which go either way, and obviously cases that depend on their particular facts. So it's a particular fact of what was the breach, what was the duty, how clearly was it that it was owed, and how clearly was it that it was breached. But the situation is that in Brookfield Multiplex, they found that the pure economic loss flowing from latent defects, there was not a duty of care owed to subsequent owners, and there was therefore no duty owed to the actual strata corporation. So that's a case that was a bit awkward, and obviously a situation where it called for a legal intervention in Parliament's view. And that's what sort of those sorts of cases and other cases we'll see have inspired the Act, and then also inspired the interpretation the courts have given to the Act over the period. So here is another case looking at whether or not there's a duty of care when it was based on alleged negligence. And the situation is that there was a finding that they owed a duty of care to the property owners. So in those factual situations, the builder was held liable. So again, another one in SECO, and the relevance is important because it establishes the liability of building practitioners, and the situation is they were obligated to comply with the relevant building codes and standards. Failure to meet these standards in execution construction works constitute negligence with implication for liability under subsequent legislative framework. So again, you're seeing a situation where there's a live issue in the community and a live issue in the litigation, and the courts are advancing towards a situation where the builder owed the duty. In another Brookfield case, they found that they owed a duty to protect the subsequent owners to ensure they complied with relevant building standards. So the situation coming out of those cases is that you have to be extra vigilant in your design, extra careful in what you're doing, and also double checking, because the circumstance is if you've done a design, the absence of a peer review sometimes means that the design is crook in some way and isn't remedied. And the circumstance is that, again, you should document clearly, because it may be that somebody has told you at some stage that you can assume this, this, and this for the purpose of your design. Unless you document what you're assuming and who gave you the authority to assume it, then your design might look to be vulnerable and without any any reason. If, on the other hand, you had a reason by a fairly competent sort of source that told you you could assume certain aspects, then of course you might have discharged your duty of care. Looking at here was a case where it's a 2023 case, so it's after the Act comes in, and they're trying to have a benefit of the Act in being able to recover under the DBPA. So Section 37, which we've seen shortly, says there is a duty of care, and it related to the effective cladding on the facade of a strata building. So they wanted to amend their claim to include a claim under the Home Building Act and a new claim under Design and Building Practitioners. And there the judge rejected the Home Building Act amendment due to the prejudice being the delay that there was in bringing it. However, he allowed the amendment to add the new claim. There was an adequate explanation of that delay, and the builder was not prejudiced. So the circumstance is then you'll see that this Act is coming in and it's making sure that there is a claim there to be looked at. The issue is when some of these issues come up, they come up while the matter is before the court and while the court is trying to decide how to deal with them. And the court has a policy that if you delay in bringing your case to court and that affects the other parties, then the situation is there's a tendency not to allow you to amend or expend your claim. And that was the case in this matter. The other case was Doyles Constructions in Warragamba Shire Council. And there they sought to expand their claim to join the director of the builder and his site supervisors as parties to the proceedings. Presumably they were doing that because the original building company wasn't very substantial and perhaps didn't have any insurance that would respond. So in order to sort of put some pressure on the resolution of the case, they sought to join the particular people. And Doyles, who was the defendant in it, objected to that and argued that the individuals are not relevant persons within that meaning. But Justice Stevenson allowed the joiner. He found that directors and supervisors can be persons who owe a duty under the DBPA. So it's important to sort of understand that directors and supervisors can mean ordinary individuals carrying out their normal, ordinary work and, to all intents and purposes, doing a reasonable job. So the situation is that Stevenson said the word the Parliament has used to determine who are actors is person. I'm able to see by what process of statutory interpretation that word could be read down to mean a person acting in their own capacity. So the situation is he was pretty straightforward and clear cut on saying the Act says that persons are liable, and if you're a person, then you're liable. The other sort of aspect is that he looked at the role that people had. That is, Mr. Bowles had the ultimate ability to control how the works performed by the builder were carried out. So Bowles was supervising it, and McCarthy actively supervised, coordinated, and project managed. So again, situation is project management. You need to be making sure that not only are you progressing the works and motivating everyone to get the job done, but you've got to be careful that it's defect-free. Otherwise, you might attract that liability later. This was an interesting case of LULAC, and there the situation is that the parties were debating how to prove that a breach of the duty of care had occurred. And the situation is the plaintiffs in that case said, well, you owed us a duty of care under the Act, and the situation is the defects are obvious after, say, 2 years. So it's obvious, that is, you had a duty of care, the defects occurred, and therefore you're liable. But Stevenson said, no, that's not enough. What you've got to do, in his view, as his interpretation of the Act, is that you've got to identify exactly what went wrong to show that it was negligent. So again, we're going back to the basic distinction between a contract and negligence. The new Act doesn't impose a duty that's strict liability like contract would be. It imposed a duty modelled on the old common law, which is you have a duty of care and you must show a breach of that duty. So you have to show what risk was, what risk was foreseeable, what precautions should have been taken to avoid it, and was it those precautions easy to take, and therefore did they lead to the actual defect. So rather than simply saying the window leaks, it's your problem, you've got to actually say, well, hang on, the window leaks because of defective flashing. The defective flashing is crumpled and not put on properly, and what should have been done was, before you put the window in, you should have made sure that all the flashing was in the right place and placed the window in gently. And then if you specify that, you give the defendant a fair shot to say, well, I did all those precautions, but it still worked badly, or no, sorry, I didn't do that precaution, so I might be liable. So it's an important case, and what it's led to in the Supreme Court is a very intricate set of pleadings where you have to plead each particular risk, whether it was foreseeable, whether he could control it, what were the consequences, and how it led to the damage. And the circumstance, it's a somewhat of a break on the claims that can be made, because you must articulate that to get a claim up. In the more liberal days of years ago, you could have relied on the Latin maxim of res ipsa loquitur, which says the matter speaks for itself. So in that case, say a man walking past a loading dock and a lump of concrete falls on his head, he says, I don't have to prove negligence, that the matter's obvious, you must have dropped it carelessly. But this Act and LULAC takes a different approach. It says, no, you must specify it. So the issue is that, as it says here, there is no provision in the Act stating that the mere fact of a defect establishes a breach. You've got to show that the defect came because of a lack of care. So that's a need for very specific pleading and very careful forensic investigation when you're investigating or reporting on defects. In here, the builder argued for proportionate liability. So the builder is saying, well, I might be responsible for some of it, but I employed a qualified architect, so he should take 30%. And I employed a careful supervisor, so he should take 50%. So I should only be liable for the 20% in the middle. And the court said, no, you're liable for the whole lot. It's a non-delegatable duty. So if you as an engineer get out there and change the design on the drainage pipes and it all overflows and ruins everyone's carpets, then you might be responsible for picking that up. And you can't say, well, it was a carpet layer and I don't have to pay. So you pay the whole lot and you get what you can back from the carpet layer if he was to pay. So it's an important sort of aspect to say it's a non-delegatable duty. So the situation is that it's not consistent with the character of the builder's duty as non-delegatable. So they're saying, no, you're stuck with it under this act and you can't get rid of it by passing it on. They did say it's entitled to cross-claim against concurrent wrongdoers, but it cannot reduce its own liability for the whole loss suffered by the applicant. So it's quite an important sort of aspect, because in other circumstances, proportionate liability allowed people to bear their share of the loss and not the whole loss. The old common law was if you had two wrongdoers, they both were responsible for 100% if the other one went broke. However, the situation is with proportionate liability that one of them can say, I was only 10% responsible, and therefore he gets off just by paying 10%. Concern here is that the DVP Act has wiped that out because it's non-delegatable. So the other aspect is that you've got to be careful of with designs, of course, is the physical injury aspect. And that is where you've got a situation where you're going to be responsible for the injuries to people. Again, the circumstance is you're designing the formwork for a concrete pour. You think you've got it right. You pour the wet concrete on and it collapses. Well, if it wipes out a few concreters, you might get a very substantial claim out of it. So safety is another ever-present risk in construction. And it's ever-present that you can prove that you've done what you need to do to make sure that there's no lack of safety from your point of view. So this, when we look at it, design is important to look after your liability in that respect. The first step is to define the extent of your design, so the extent of your responsibilities, and make sure that that's signed off by people. The next aspect is once the design is, progressing, you should get progressive sign-offs. That is, you're saying, well, look, I'm designing the structure, but I'm not designing the cladding, and you get that agreed. And then the situation is I'm designing a structure to restrain wind loads, and I also want to do a bit of earthquake, but only up to, level 4.5. So the situation is that you can define the extent of your responsibilities, and if you get that signed off by whoever's you're reporting to, and your role is limited, then you've got a better chance of protecting yourself in later events. So it's important as well to make sure that what sort of liability for design are you accepting? Are you accepting simply to design something so it absolutely works? So somebody comes to you and says, look, I've got a $4 million boat and I want to design an anchor that'll hold out in every storm, and I want you to contract that you're the bloke to do it, well, then that's a heavy, strict liability sort of environment. On the other hand, if you say to him, well, I don't know much about boats and I don't know much about weather, the reality is I'll design it for this sort of weather and I'll design it for this sort of boat. Now, that's the end of my responsibility. I'll do a careful design for you, but I can't take any responsibility for unexpected environments. And he agrees, and that's signed off, then you've got a much better chance of protecting yourself. So it's important that you get a clear aspect of design up front. The other aspect is the design process that you follow will be relevant to the level of care that you've disclosed. So if you have a design aspect where you simply photographed the last design you've done and you've used it in the next design, you'd be taking some risks. Well, in earlier times, I had designed a swimming pool for a concrete swimming pool installer, and I had got it down to the stage where it was pretty robust design and it would work in all circumstances, provided it was a reasonable hole and you put it in, this design would work. So I was making, at that stage, a reasonable sum in those days for the design by photocopying it, because it would work in a wide range of environments because it was fairly conservatively designed. Well, you'd worry about that under the new Act, because I wouldn't be able to show that I had actually carried out a careful process of design. You wouldn't be able to show that I had looked at the ground conditions and looked at the loading conditions and looked at the extent that the pool would stand above the supporting ground, or looking at the perhaps better specification of the bed that it was to be bedded in, to show that if it cracked up, I wasn't liable. So again, since those days, life has got tougher and the responsibility on designers has got more pressing, both to get the design right, but to show along the way that it had been done in a careful and professional way. The other aspect about the Act, of course, for design responsibilities is that the regulatory authorities have wide-ranging powers to investigate, wide-ranging powers to call people to give them information, and wide-ranging powers to penalise people and prosecute them for it. And that comes out of Parliament in New South Wales having a very deliberate sort of concern over the high-rise buildings that were collapsing and causing lots of loss to lots of people. And they said, well, we'll put a stop to it. We will make sure that we clean up the industry. And the people that have been appointed to clean up the industry were pretty blunt about it. That was their job and that's what they had to do. And they weren't taking too many prisoners in that process. And that is that if you fell out with any of the criteria that they'd come to expect was reasonable and important, then they would take the obvious steps and people would be, effectively pushed out of the industry. So it's a very important aspect now, and it's more and more important because it's if you take a design engineer or a design architect, he's dealing not only with the longevity of buildings, he's also dealing with the safety of buildings. And similarly with the high concern over the cladding on buildings, the London fire and other incidents have caused people to realise the importance of good design and realise the importance of good building practices, and to make sure that that was going to be insisted on. At the same time, society's in a situation where it has to have buildings, it has to have buildings designed, and it has to encourage the effective and efficient building of those buildings. So this Act is its attempt to strike that balance between good building, good design, and efficient design. That was the ground that I wanted to cover today.